Good evening, one and all. I welcome everybody present here to this year's first CME, and I request Shri Bharat Kumar Mehta sir to welcome the resource person of this today's CME and to proceed with the program. Sir, please.
Thank you, sir. Good evening, friends. I wish one and all a very happy new year 2025. So I have the privilege to introduce my colleague and esteemed good friend Shanta Chellappa, wherein we got mediation training together in the year 2007, and I had the privilege to do joint training, co-training in Hyderabad MCPC program, and that was a wonderful program. She has profound knowledge on the subject, and I'm sure that she will do justice on today's topic, which is changing dimensions in mediation in view of Mediation Act 2023. I, on behalf of myself and on behalf of all, welcome Shanta Chellappa. Thank you.
Are we ready? Because I feel so funny when Bharat introduces me to this group, whom I know from since how long? From maybe 2008. Almost everybody we know each other. Anyway, first let me wish you all a very wonderful year ahead. Yeah. With full of happiness, prosperity, good health and professional satisfaction. Okay, na? Is it okay? So we all agree that mediation is it's been long been recognized as a very effective collaborative negotiation. Can you hear me? Yeah. And it's a fascinating journey to trace from the time we started mediating, once it has been, when Section 89 was reintroduced with adding ADR processes. That is somewhere around 2002 it came into, till today, where we are standing here with a standalone enactment about mediation, which is waiting to be come to force, right? It's a real journey. If you see that mediation journey, after Section 89, we all know that in Companies Act, Section 442 was introduced to introduce mediation. Later, and that provision enabled NCLT, central government and the appellate tribunal to refer matters suo motu or on the application of the parties for mediation to the panel of mediators attached to the NCLT and appellate tribunal and all. Then at a later stage, Consumer Act also included Chapter 5. We all know about it, right? Where the entire chapter was dedicated to mediation, and under the Consumer Protection Act, the commissions can suo motu or on the application or on the request of the parties can refer matter to mediation. Then came pre-litigation mediation, Commercial Courts Act, Section 12A, which is made it mandatory. So this in bits and pieces mediation was introduced, And along the side, private mediations were also gaining strength. You can see that there were private service providers who have been offering mediation services. But the one hitch is that under Section 89, when we mediate court-referred matters, that go back to the court and order is passed in terms of the settlement terms. But whereas in private mediations, what happened was we have an agreement on hand which we have to file a specific performance of the act. Or on the other hand, we all started doing it, converting it into a conciliation award in order to have enforceability. So one of the main features of that, before this act has come into force, not that it has not come into force, before the act was enacted, enforceability was a difficult proposition. And it did not, the parties also hesitate to try mediation because of this provision. So by changing dimensions, what I am trying to explore is that along with you, what are the provisions of the act? We are doing mediation now, guided under Section 89 of the CPC, guided by the Civil Procedure Mediation Rules 2016, which has been formulated by the High Court of Karnataka. But here the Mediation Act has included provisions which are setting it, giving it a legal framework. It gives it more strength and teeth to work on this process. So how many of you have gone through the act? Most of you? Most of you have done it. So what according to you, as you think, because I also say, here I am here to explore the act along with you. So maybe I might miss certain important provisions. So what according to you, the important provisions which has given teeth this, which has given a better legal framework, accessibility, and also for the parties to look at this process along with the judicial process. Can anybody come back with your thoughts? Yes. Pardon? Yes. Pre-litigation mediation. Then? Enforceability of settlement agreement. Then? Online mediation. Yes. Community mediation. So there are certain enabling provisions, and we have, let me take it one by one. So let me just read out the preamble. Okay? What does the preamble say? The preamble says, an act to promote and facilitate mediation, especially an institutional mediation, for resolution of disputes, commercial or otherwise, enforce mediated settlements agreements, provide a body for registration of mediator, to encourage community mediation, and to make online mediation as acceptable and cost-effective process and for matters connected therewith. So whatever you have just said has been covered under this preamble. In addition to that, institutional mediation, something like an arbitration. We are also, this act is also there to promote institutional mediation. So what by institutional mediation, what is that they say? They are bringing in mediation service providers as a viable process because the parties can decide what is that with whom they want to go ahead. Especially the pre-litigation mediation, along with the court-annexed mediation and pre-litigation mediation for authorities under the Legal Services Authority. Mediation service providers have also been included, which is giving not only for it's the convenience of the parties, it is also giving as an opportunity mediator to have a professional expertise in that line. It is opening up a venue for us to try mediation as instead of doing it pro bono, it can be a profitable business which we can take it, or as we are practicing law, we can practice mediation. So we all know that mediation, when we say what is the definition of mediation? We really don't have a definition. In the training, as we say that mediation is a process where both the disputing parties try to arrive at an amicable solution with the help of a third party neutral who facilitates the negotiation process. So what does the Act defines mediation? The Act defines mediation as, let me just read out the Act. Under section 3H, the mediation includes any kind of process, by whatever name it is called, whether it's a pre-litigation mediation or an online mediation or a community mediation or a conciliation or of any other import, or something similar to all these things, wherever the parties try to arrive at an amicable solution with the help of a third party who is called a mediator. This is, so here what has happened was there was a thin line between mediation and conciliation. There's always been a confusion whether it's a mediation or a conciliation. Now that confusion has been put to rest. Wherever it is mentioned as conciliation also, it's a mediation process. Hereinafter, after the Act has come into force, it will be a mediation under the Mediation Act. In order to make it comfortable, even some of this Act has got certain schedules wherein the word conciliation and different enactments have been given a new meaning as a mediation under the Act. If possible, I'll go through one by one if I have the time. Otherwise, I will just move forward. Let me see. One, you can look at it, Schedule 6, where the conciliation from section 43D of the Arbitration and Conciliation Act has been substituted for the following. The Act says, section 61 is substituted for section 61 to 81, which deals with the entire process. 61 to 81 section deals with the conciliation under the Arbitration and Conciliation Act. But what does the section 61 say? Substitute says, reference to conciliation in enactment. Any provision in any other enactment for the time being in force, providing the resolution of disputes through conciliation in accordance of this Act, shall be construed as mediation under the Mediation Act. So completely the conciliation provisions have been removed from the Conciliation Act. Similarly, under Schedule 7, it talks about Micro, Small and Medium Enterprises Act. There under section 18, there is a provision, sir, any claim is made under section 17, the Facilitation Council can act as a conciliator by themselves or refer the matter to an outside agency for conciliation. That has been substituted to say it should the facilitative committee can act as a mediator by themselves or they can refer to a service provider. So that wherever, similarly, under Schedule 10, it stated that under the Consumer Protection Act, we all know that there is a Chapter 5. It's completely deals with consumer mediation. That chapter has been removed. So section 37 of the Consumer Protection Act reads like this. The district commission or state commission or the national commission, as the case may be, either on an application by the parties or suo motu, they can refer the matter to mediation under the Mediation Act. So these are the, wherever the conciliation is provided or mediation is provided, the Mediation Act has been replaced that. So the next salient feature of this Act is section 2, to what cases the Act applies, okay? Where mediation is conducted in India. This Act is applicable where mediation is conducted in India. And it can be either be a domestic mediation or an international mediation. When they talk about domestic mediation, where one of both the parties should be residing in India, it can be either civil or matrimonial or any commercial matter, or it can be an international mediation, or one more enabling provision is that government, either is a central or this is one of the enabling provision of this act, which I feel that we all know that government is the largest litigator. So this provision applies mediation in commercial matters only. In commercial matters, the government, any public body or any company which owned by the central government or the state government, wherever there is a commercial matter, it can be referred for mediation. This section also enables the government to bring in other cases in appropriate, if the court, the government feels that it is appropriate to bring in within the ambit of mediation. And when then it also includes international mediation. When it call it international mediation, we need to understand what is international mediation. International mediation is something where there is a dispute, which is the dispute should arise out of a legal relationship or a contractual relationship under the provisions of the acts which are available in India. And one of the parties should be residing outside, or it could be a company which is incorporated outside, or it could be an association or a body which is incorporated outside, or a foreign government. So even these matters can be mediated under the Mediation Act, and also this act says that wherever there is an agreement that when there is a dispute, then the mediation should be conducted under the Mediation Act of 2023, then it has to be conducted only under Mediation Act. So these are the very enabling provisions, because bring into our this thing other international and domestic mediation and government mediation within the ambit of mediation. We also know that India is a signatory to the Singapore Convention, which is applicable for the enforcement of a mediated settlement arising out of international disputes. But the only thing is that it has not been ratified. As a result, any settlement cannot be enforced within India until the UN Convention is ratified by India. The next one, which I consider as an enabling provision, is the jurisdictional flexibility. This is dealt under section 13 of the Act. See, we all know that most of the cases have to be conducted within the jurisdiction of the competent court or the tribunal. And that's what its section also says. Generally, the mediation has to be conducted within the jurisdiction of the competent court. But if both the parties decides, they can conduct the mediation anywhere in the country. If they think, maybe they choose Bangalore Mediation Centre, a person living in Delhi and having a dispute there, he chooses, I prefer Bangalore Mediation Centre because their mediators are more efficient, they can come over here and get it done. That is the beauty of, there is the convenience for the parties with their consent. If they have the consensus, then they can do it. And apart from that, online mediation, parties can live anywhere. And you are all doing online mediations, right? Each one of us, I can see that on the video conferencing and through audio conferencing, through chat box, everything you are doing it. So even online, wherever it is conducted. But for the purposes of enforceability, registration and challenge, it has to be done within the jurisdiction of the court, which has got the jurisdiction to try this matter. That is the only exception to these provisions. I am sure you will all agree that it's an enabled provision, because it not only it gives, easy convenience for the convenience of the party to attend a mediation wherever they are. And the mediators can also, if the parties believe in that particular mediator, wherever they are, they will come to you. That is the beauty. Then we can also, if we are going to keep ourselves always in touch with the subject and we keep improving ourselves, we are there for them to help others wherever they are. Then what is the next enabling provision? I ask pre-litigation mediation. That is dealt under section 5.1. We all know that pre-litigation, and we have all heard and we have an idea and your exposure to section 12A of the Commercial Courts Act, where the pre-litigation mediation, where there is no emergency of interim order, it is mandatory, right? Similarly, section 5.1 also, with the consents of the parties, even if there is no emergency, whether that is a civil or a commercial matter, if the parties agree, they can go in for a pre-litigation mediation instead of going through the litigation process, which certainly stresses out, and it is also a long drawn process. But why? I feel this pre-litigation mediation is a enabling provision because subsequently we are going to look at the enforceability and also the status of the mediated settlement. Because under section 27(1) of the Act, it says that when a mediation agreement is entered into, signed by the parties, authenticated by the mediator. This is one step further, authenticated by the mediator, we have not been doing till now, right? But under the Mediation Act, once it's come into force, we'll be authenticating the mediated settlement. This settlement gets the status of a decree and it is enforceable under the Civil Procedure Code. This is something which is very good, especially in a pre-litigation mediation. If the parties arrive at a settlement, there is no question of going to the court at all because the settlement agreement can be enforced under CPC. And as we go through pre-litigation mediation, I would also talk about post-litigation mediation. Post-litigation mediation, we are all doing it under section 89 of the Act, under the guidance of rules framed by the High Court of Karnataka, right? Under 6.1 of the Act deals with post-litigation mediation. It says that when there is no settlement arrived at in pre-litigation, at any stage of the process, the parties can opt for a post-litigation mediation, either to mediators or to a mediation service provider. And at that time, when the parties are opting for post-litigation mediation, this court can pass an interim order in order to safeguard the interest of the parties. This is one of the enabling provision which will give the parties a motivation to try mediation, or if they are not in a mood to do it, there is something which will really enable the parties to come instead of going through the long drawn litigation process. This is under section. Under section 6, the section says whatever identified under schedule 1 of the Act cannot be mediated. We all know that. Till now, we have been following Afghan case, right? Criminal prosecution matters where some of the criminal non-compoundable criminal matters, PAL, then where minors, deities and intellectual capabilities, person without intellectual capability, all those cases, and where there is a declaration needed against the government. Some of the cases which we see, we feel that that's what Afghan has said, which cannot be mediated. The same thing, whereas the Schedule 1 of the Act not only includes what is contemplated under Afghan, it also more than that. It's an exhaustive schedule. I think each one of us should go through that before deciding. Instead of going into the whole thing, you can do that. But another important enabling provision which I feel is we should all know, because some of us still, we are all not only practicing advocate and also mediators, MVC cases. Under 5.6, the Act says that, now we all know that MVC matter, the first step for the resolution is that the insurance has to offer certain compensation to the parties, and the party agrees, then the court passes an order. Am I right in saying that? People who have been doing MVC matters may correct me if I am wrong, under section 149. But what this 5.6 says that, if there is no settlement under section 149 of MVC Act, even then the court has to send the matter for litigation, mediation for them to arrive at a settlement. Only if there is no settlement under that, then it goes back for trial before the MVC claims tribunal. Why did this happen? We all know about Krishnamurthy versus New India Assurance Company, where the Supreme Court has advised that motor vehicle accident claims should go for mediation, and also the court recommended that there should be a standalone mediation, if I remember correct, right? That was the starting point for looking at, am I right in that saying that? Okay, yeah, yeah. So that is something, because of that, this provision has been included under section 5(6). Then comes mediator. What is the definition of mediators under the Act? Any person who has been appointed by the consent of both the parties or by a service provider in order to conduct a mediation to resolve the dispute between the parties is the definition under the Act. And under section 5(3) deals with what kind of mediators, who can conduct pre-litigation mediation. As of now, under Commercial Courts Act 12A, the mediators identified by the Legal Services Authority can conduct, right? It says that any authority who has been identified or empaneled under the Legal Services Authority or any other authority specified by the government or a mediation service provider or any mediator who is registered with the Mediation Council can conduct pre-litigation mediation. As section 8 also, who can become the mediators? We have certain provisions under the rules, right? High Court rules, who can be trained as a mediator. It says that a person who has been 15 years of service, a lawyer or any other professional who is around 15 years of practice or expertise in their field can be trained as a mediator. But here the section says even a foreign national can be trained as a mediator to conduct mediation in India, because this is applicable only to the mediation, domestic and international mediation conducted under the laws of India. But he has to have the qualification and accreditations and experience as going to be specified by the government. So far they have not specified it. What are the qualifications to get trained? Hopefully it will come when they frame the rules. This is what it says. So, and how can they be appointed? The mediators can be appointed by the consent of the parties. Till now, we are more exposed to court-annexed mediation. Here the parties have no choice to select their mediators. Generally, it is the organization which selects. In private mediation, even now they have the option to select the mediators to the organization. So, who can select mediators? Normally, the consent of the parties, they can select the mediator. Only if they are not able to select the mediators to conduct the mediation, then they can approach the mediation service provider who can select the mediators for them, and the mediator has to accept that within 7 days, and if it doesn't accept, then they have to select another mediator. And all these provisions are given under the Act. So, next I would like to talk about the time frame. So, as of now, we have, I think, 60 days plus 30 days, which can be extended by the court with the consent of both the parties. But the Act gives 120 days, which can be extended with the consent of the parties for another 60 days. So, totally, we have our 6 months period for completing a mediation process, which I feel is fair enough to have a good mediation conducted for all of us, because we also need time. We can't be just pushing without, there's a collecting of information. There are various steps we have to follow in mediation. This is something similar to fast track arbitration. People who are doing arbitration here will know that the time frame given under the Arbitration Act is 120, 1 year, which can be extended by another 6 months under 29A. But under 29B, if I am wrong, please correct me, because these are all things which I have just collected, but I am not very sure, okay? I might make a mistake also. Kindly correct me if I am wrong. What I understand is that under the Arbitration and Conciliation Act, you have a 6 months for fast track arbitration. Am I right? So in case that fails, then you have to go back to 29A. But under the Mediation Act, you cannot go back. This is the time frame that within 6 months the mediation has to be conducted, otherwise it has to go back to the court or wherever, whatever the parties decide to do. Then comes another important provision of this act is confidentiality and privilege against disclosure. Confidentiality, already we are all following it. We know that any submissions made in the mediation, any documents furnished or document made and offers made, whatever the statement made are all confidential, and nobody can call upon either the mediator or the parties or the expert to court or in any arbitration proceeding to understand what transpired in mediation. This is provided under the rules, right? High Court rules, it is provided between 20 to 23, I think. Rule 20 to 23 provides for that. And it also provides that we cannot be called upon to the court. Either the mediators or the parties cannot be called upon to the court. But what this section says that includes all these things, but says that for the purposes of training and for research, whatever transpired in mediation can be discussed without identifying the parties. So that will not come within the confidentiality aspect. It also says there are no privileges with reference to when there is a statement is made with reference to domestic violence or child abuse or an intention to commit a criminal offense which is punishable under the act, or a statement is made which could affect the public safety or public health. All these things, there is no confidential, they are not privileged for confidentiality aspect of the section. Then, and apart from that, I want to talk to you about the exclusion. That is, I have already told you, under section 6, schedule 1 talks about which are the cases non-mediatable. So, oh sorry, I have not even, I am so sorry. I was so busy talking to you, I have not even changed the slides. Okay, let me just go over to that slide. I never realized that. Okay. Okay. Confidentially, okay. Matters exclude. Next important is that enforceability of the section. Section 27(1) talks about enforceability of the Mediation Act. It says that yes, mediated settlement which is signed by the parties and which is authenticated by the mediator gets the status of a decree and is enforceable under the CPC Act. This is another enabling provision which could motivate the parties to go for mediation, because there is a time limit. If the matter gets settled, they can finish it off within the very small stringent time frame, even if the matter does not get settled. The another beauty of this mediation is that the advocate and the parties have to prepare themselves while coming in the first. Within that 180 days, they need to understand the case fully, the case laws and everything. So the advocate also has to prepare himself, the parties also prepare themselves. As a result of which, even for a moment assuming that the mediation was not successful at that point of time, the advocate is prepared, the parties are prepared, so that it will give them more teeth with reference to the case which they are dealing with. And another beauty of this is that at any point later, they can always come back to mediation. So that is why this time frame really helps. And enforceability also helps the party to opt for mediation before going for any litigation. And apart from that, section 21 talks about non-settlement report. And this is when the settlement report has to be signed, and in case of ad hoc mediation, the mediator signs and give a copy to the parties, and in case of service providers, it is given to the service provider along with a note who he takes care of the administration of the settlement report. And then section 21 talks about the non-settlement report, how it should be prepared. As we are doing it here, no, we are not supposed to give any reasons. We have Supreme Court cases how the settlement report have to be given, and we are all aware of that also. So same thing is also given here. The Act says that you cannot give the reasons why the settlement has failed, and you also give a details of how the discussions went. It has to be settled. If it is settled, it has to go back with the settlement terms of the agreement. If it is not settled, a non-settlement report has to go back. And then registration of settlement agreement. The Act provides for if the parties want. It's an optional provision under section 20. Section 20 talks about registration of mediated settlement. So the parties can by themselves or the service provider can register the settlement agreement if they want to. And the jurisdictional there is a jurisdictional requirement. Whichever court has got the competent jurisdiction to try this matter. As I already told you, even though if the mediation is conducted something out the jurisdictional court, still the registration has to be done within that. It has to be registered with the authority who is not yet specified by the government. So once it is specified, then and the Act comes into force, it can be registered. And what are the time frame for the registration? 180 days. Within 180 days, the settlement agreement has to be registered. In case the parties want to extend the period, beyond that, on payment of certain fees, the time limit can be extended. Then comes challenge to mediated settlement. What is your experience? Do you think that there can be challenge to mediation settlement agreement? Not really, right? That's what I also feel. As we have seen with our experience for several years, I don't think it's very rarely mediated settlement agreements have been challenged. But still, the provision has been made under the Act. But they are very stringent provision, either on the grounds of fraud or impersonation, or even coercion and all is also not there. Grounds are fraud, corruption or impersonation, or where the mediation, I'm sorry, it is there, okay, or unsuitability. Suppose an unsuitable matter has been challenged. So that also, the time frame given for this challenge is very, very stringent. From the date the parties receive the settlement agreement copy, 90 days. And if there is a sufficient cause, the court can, because it has to be done in the court, which has got like compromise decree, Order 23, Rule 3, if at all we want to challenge it on certain ground, we have to do it on within the court only, which has got similarly, the court which has got the jurisdiction to try this matter alone can go, that court can extend it by another 90 days. Then the another very important provision, which I think, maybe I am wrong, the extension of limitation period. Can you tell me, I think under the Commercial Courts Act, when it goes for mediation, there is a provision for extension of limitation. I don't know about this in any Arbitration Act doesn't have, and I don't think any other act has got, but this act has included that if the mediation is started within the limitation period, time gets excluded to that extent. This will give certain, what shall I say, safeguard to the parties. So if they feel that, because there will be a fear in the minds of the parties, if I go for mediation, if it gets, then my limitation, because I am the end, I have to file a case, then only I can go for mediation. It's not like that. If they go for mediation also. And where does it start? From the date they get a notice of under section 14, when it starts and when the report is submitted or the non-settlement report is sent. Within that is under section 24. Within that period, most likely 6 months period, limitation can be extended. Then, apart from that, there are several comprehensive provisions. The Act also says how the mediation agreement should be formatted under section 4, and how the mediation service providers should appoint the mediators, the procedure to be followed under section 8 to 12, and the guiding principles of mediation, how the mediation settlement to be drawn, and the creation of a regulatory body, which is very, very important. The Mediation Council, we all know that the sections have already been notified for the creation of Mediation Council. Not yet, as I understand, it has not yet been formulated, but it has already been notified for creation. And how the objects of, what is that the Mediation Councils should do. What are their objects, how they should register the MSP, and how they should register the mediators, and how they should recognize the Mediation Institute, workshops, everything is covered under that. I am so sorry that I could not go into details of this section for the simple reason of the time, this thing. So the role of, it also talks about the role of mediation service providers under section 40 and 41, how they can appoint, how they should accredit the mediators, what kind of a training they should do, if the mediation, how the Mediation Training Institute should be recognized by the Mediation Council, all, and their numerous functions is also dealt under the section. So under section 43, they talk about community mediation. So the Act provides for community mediation with the prior mutual consent of the parties for the resolution of the disputes that are likely to affect the peace, harmony and tranquility in a local area with reference to family and then group. But this has to be either the authority and the legal services authority or the district magistrate or subdivisional magistrate has to constitute a mediation committee consisting of 3 mediators. It also says that women should be given importance, all those things are there in that. And under section 655, this Act expressly provides that certain acts are not overridden by this Act. They are Industrial Disputes Act and the Family Courts Act. So they have their own conciliation process well set, so it has not been overridden. Otherwise, all other acts where conciliation has been provided has been substituted with mediation. So to me, on the whole, I feel that this is a act which is what shall I say, it is a comprehensive act addressing several aspects of mediation. Maybe some of you might think there are certain other aspects which could have been addressed. If you can come out with that, I am sure I will feel more happy to get enlightened about it. To me, I have still not found out. I feel that this is, hopefully it's a good, maybe as we start practicing it, we might come out with something. But any other aspects which you feel could have been included in this Act? Rukmini? Pardon?
Making it mandatory.
Yeah.
Don't you think in our legal scenario, it would have been better? Now only the Commercial Courts Act section 12A says...
Supreme Court has also said that, but there is a glitch there. There is an... if there is no emergency for an interim order. But what I was recently, I think Patel... it said even if there is they can take an interim order and then go for mediation, right? So maybe if, I do agree that, but on the whole mediation, we don't support mandatory provisions. We all know that even Italy...
But mandatory is only for coming in for mediation, not for settling. So, you come in, but whether you settle or not, is up to the parties.
That's
It-
what,
yeah.
see, if you read section 89, if I'm wrong, please correct me. If you read section 89 along with order 10 rule 1A, B and C, reference is made mandatory. Am I right? Reference is made mandatory. So the part, and under the rules, I think rule number 24, the High Court rule says that if the parties do not attend a mediation, the court can impose cost on them. So I feel that as of now, maybe that is a provision which could help the parties. Maybe we have to tell them. See, the court has to tell them. It's not us, we have to do it. The
Court has to do it,
tell
exactly.
them that there is a problem. I think some of the courts also impose cost. I think I have heard somebody telling me one of the family court has imposed a cost when the parties did not attend the mediation. I don't recollect, but in one of the matter, no. So at least the court can say, court can do it. They can impose cost if you are not going. Because we also don't say that why the matter has not been settled, we say either the plaintiff or the defendant has not attended the mediation for several. So if that report goes back, then the court can impose cost so that the parties and the advocates will be aware that they can't consider this, take it as a formality to attend. That's, I don't know. Maybe it's a good
Thank you.
thought. We
Thank
need
you.
to do it. And thank you very much for listening to me for such a long time. I do hope I had shared some of my thoughts with you. The time is okay? Is it okay?
Hello.
What is the present status of the Mediation Act?
Hello.
Anybody who can throw some light, everybody can. Really, someone should really find out what is happening.
Secondly, what is the loophole according to you in this act? If there is one, I'm not saying there is loophole, I'm asking you whether there is any loophole.
As Rukmani said, sometimes I felt that at least attending the first two sessions, it was there in the proposal.
Draft.
At least that if they've retained, it would have been good because again it becomes our responsibility, mediator's responsibility to make them understand that this process is going to help them. So we will also be more alert, tell them how, because our opening statement has to be very effective for us to make the parties understand, I have come to a place where it is going to be settled. I am going to make a sincere attempt. So if that is there, it would have been better. That's one of my thoughts when we, at
Okay.
least two sessions. I'm not saying that, and then we can go back with the volunteer.
If we emphasize more on the benefits of mediation and settlement in mediation, parties will evince more interest. The process, more than the process, the benefits has to be more emphasized. Okay. Yeah. Yes. But this extension of the time limit can be misused also by the parties. That is, extended time limit can also be misused by the parties. Yes.
Want to be in the public domain. So if it is then it's totally a confidential process. So even if they need not have to register, it's only an optional thing. So if he wants to keep it totally confidential, they can do it under mediation, which is not possible in arbitration as well as in litigation. It is true arbitration is a private adjudication, but that still it can be in the public domain, whereas mediation can be completely confidential. That is one of my feeling that it's a good benefit.
Shanta, what is the advantage of registering it? That's all, no?
That's all. There is no such thing as benefit under that. If somebody wants, see, some people will think that, like, register the document, then I feel more comfortable with that.
Okay,
So,
okay. It's just a mental,
it's just a
an
mental.
assurance.
That's what I feel.
Oh,
because
assurance.
there's no need for a registration. Because most of the people, if they want to keep it confidential, they may not like to register it also. That's what I feel. I don't know.
So, anything from Dharwad and Kalburgi bench? So, any queries from Dharwad and Kalburgi bench? Should we take it as no?
Yes.
So,
Yes.
on behalf of Karnataka Mediation Centre, sorry? Gulbarga bench, any interaction? Would you like to interact with ma'am? Dharwad bench. So, I take it as no? Okay.
I go around with the mic.
So, on behalf of Karnataka Mediation Centre, I thank our speaker, Srimati Shanta Chellappa, for sharing such valuable insights and broadening our understanding on this topic. It was very interesting, ma'am. Thank you so much. I sincerely thank our Honorable Board of Directors, all the registrars of High Court of Karnataka, Bangalore and bench of Dharwad and Kalburgi, our Honorable Director Shri S. Gopalappa, our Honorable Deputy Director Shri S. S. Bharat, all mediators for actively participating, all the trainee mediators, technical support and the staff of Karnataka Mediation Centre. Thank you everyone for your valuable time and involvement. Thank you.